Good evening. My name is Angel Kelly. I'm a Superior Court judge and my pronouns are she, hers, and hers. Thank you for participating in this statewide virtual conversation with the Chief Justices of every state court in the Commonwealth of Massachusetts and the Commissioner of Probation on the topic, Confronting Racism in the Courts. We host this dialogue virtually because the pandemic prevents us from doing this in person in the community. Thank you to those who are returning from last year's listening session at Roxbury Community College, and those of you joining us for the first time. Please allow me to place tonight's program in context. Last year, we hosted our inaugural Black History Month event when the Massachusetts judiciary publicly acknowledged the 400th year anniversary of the commencement of slavery in the United States and the centuries of discrimination that followed. More than 20 judges went to Roxbury Community College, and we invited the Black residents of Boston to share their experiences with the court system with the intent of starting the conversation on how the court system can achieve equal justice for all. As Massachusetts was a leader in the abolition movement and many other areas of social justice, we hope to continue that tradition and be leaders in the movement against racial injustice in the legal system. Our efforts began before last summer's national awakening and reckoning with racial injustice, and more importantly, our efforts will continue well beyond this year. While in Roxbury, we heard the frustration in the voices and words of the participants, and we witnessed the tears shed as the members of the Black community shared their experiences with the court. The community's demands to be heard without filter was so great. We ran out of time to hear from everyone. As a result, we decided to continue these conversations on a regional level, and we returned tonight to expand that direct communication with the Chief Justices of our courts and to hear their efforts and plans to address the racial inequities that exist in the justice system. We hope to assure you we are committed to the delivery of equal justice for all. To preserve time for what we anticipate to be a robust conversation, each Chief Justice has also pre-recorded a message on tonight's topic that will be available to the public. Please let me introduce to you our Chief Justice, our new Chief Justice of the Supreme Judicial Court, Kimberly Budd, and Chief Justice of the Trial Court, Paula Carey, for opening remarks, to be followed by our new Court Administrator, John Bello.
Thank you, Judge Kelly, for that kind introduction. I appreciate all of the work that you and the members of the Planning Committee have undertaken to organize this important event. Thank you also to Trial Court Chief Justice Paula Carey and to all of the Trial Court Department Chief Justices for being here and for your efforts to address the issues that we'll be discussing this evening. Most of all, I'd like to thank each and every one of you in the audience for joining us. Your voices are so important. We appreciate you taking the time to share with us your experiences, your questions, and your ideas. This evening, we're continuing a conversation that we began just about a year ago with a listening session at Roxbury Community College, and that has since been carried on through virtual sessions with other communities across the state. So much has happened since we've held that first listening session in February at RCC. There have been so many tragedies in the past year that have shown a harsh light on the inequities in our society. A year ago, we were only beginning to grasp the terrible threat posed by COVID-19. We had no idea of the enormous disruption and devastation it would soon cause, with its hardships so often falling heaviest on those who can at least afford them, especially in our communities of color. My heart goes out to all of you who have lost a family member or a friend, or your job or your home due to the deadly pandemic. A year ago, we did not yet know the names of Ahmaud Arbery, Breonna Taylor, and George Floyd. But now they have joined the long list of those who remind us that too often, by too many, Black lives are not treated with the dignity and respect accorded to white lives. In the past year, we have also received 2 new reports documenting the disparate treatment of people of color in the state's legal system. Last September, Harvard Law School released a study of racial disparities in the Massachusetts criminal justice system. The study concluded that Black and Latinx people are overrepresented in the Massachusetts criminal caseload compared to their population in the state. It also found that Black and Latinx people receive longer sentences than their similarly situated white counterparts, primarily due to differences in initial charge severity and the impact of mandatory minimum sentences. And just this month, the Supreme Judicial Court Standing Committee on Lawyer Well-Being released a summary of its meetings with the state's affinity bar associations. The summary describes how attorneys of color and those from other historically excluded populations often experience increased scrutiny, unfair assumptions, and insults to their professional integrity, professional identity and integrity, and sometimes their personhood from the moment they set foot in a court building. I want to emphasize that both of these reports were undertaken at the request of the Supreme Judicial Court. The Lawyer Well-Being Committee is a committee that was established by the court in January 2020. The Harvard study was commissioned by my late colleague and friend, Chief Justice Ralph Gants. Chief Justice Gants was passionately committed to the ideal of providing equal justice for all. And his sudden death last September, shortly after the Harvard study was released, is another one of the tragedies of the past year. Both the Harvard study and the Lawyer Well-Being Committee report are part of our ongoing efforts to identify and eradicate racial and ethnic disparities in the legal. Facing up to the issues raised is a necessary step toward that goal. And the next step, which we are working hard on now, is developing more effective solutions to eliminate these disparities. Meeting with you this evening is another critical component of that project. This ongoing dialogue between the courts and the community is essential because it gives us guidance on how to better serve you and what we must do to live up to our ideals. The most important message that I want to convey to you tonight is that this is your court system. It's part of your government. It belongs to you, the people of Massachusetts. We are here to serve you, all of you. Everyone who interacts with the court system deserves to be treated with the same courtesy and respect. It doesn't matter if you walk into a courthouse or appear virtually on screen, whether you are a litigant or a lawyer, a juror, or a witness, a reporter, or a spectator. Whether you know everyone in the courtroom or you know no one. Whether you are Black or brown or white, whether you are a person with a disability or not, whether you are a citizen or not, whatever your color, ethnicity, race, religion, national origin, economic or immigration status, sexual orientation, or gender expression, you deserve to be treated with dignity and fairness. We are committed to this principle, and with your help, we will continue to strive to meet it for every single person who comes into the courts of the Commonwealth. I look forward to our conversation and to hearing your ideas about how we can do that more effectively. Thank you.
Thank you, Chief Justice Spud, for those remarks and for your leadership. Also, great thanks to Judge Kelly, John Lang, Sharice Perry, and Jessica Roman Alvarez, and others for your incredible work to make this conversation happen. We are truly here to hear from you. My name is Paula Carey, and I'm Chief Justice of the Trial Court in Massachusetts. And as this nation observes Black History Month, we pause to celebrate and honor the contributions, accomplishments, history, and rich heritage of African Americans to our courts, communities, and society. We also remind ourselves that Black history is American history. The two are inextricably linked in the fight for justice and equality. Events of the past year, from the COVID-19 pandemic to social protests for equality, continue to highlight the disparate impacts that people face directly related to the color of their skin. As a society, more importantly, a justice system, we must continue to bridge the racial divide, eliminate racial disparity, and define strategies that more effectively address the issues that impede our progress. The court is committed to addressing these issues and to strengthening public trust and confidence in the court system. Each of us has a role, and collectively we must work to ensure that our system is just and equitable. As the Massachusetts Trial Court, we join the legal community in recommitting to the, quote, the systemic change needed to make equality under the law an enduring reality for all of us. This is what was urged by the 7 justices of the Supreme Judicial Court this summer. Dedicating resources to acknowledge and address race in the justice system is not a new venture for the Massachusetts Trial Court, but we acknowledge that some of our efforts to date have not done enough to move the needle. The number of Black employees and employees of color is insufficient, especially in the judicial and the clerk magistrate ranks. Our numbers are not where they should be. It is our obligation to hire people of color in leadership roles and to do more to mentor our diverse talent and create pathways that would enable them to move up in the organization. It is also essential that we identify, recruit, and attract and develop lawyers of color to build skills to gain a judicial or clerk magistrate appointment and other positions within the court system. As members of the trial court, we hold unique positions as leaders in the justice system, and we need to be comfortable with being uncomfortable because this work is not easy. We will be more introspective about the fact that what we do and what we fail to do impacts the lives of others who have experienced the indignities of racism and injustice throughout their lives. We need to listen to the experiences of Black and brown people of all color, as we work together to try to change our system. The time is now, and it will take all of our collective efforts to eradicate racism in our justice system. Failure is not an option. We must achieve racial equality and justice for all, especially for those most deserved by our nation's justice system for centuries. I look forward to our conversation, hearing your ideas about how we can do that more effectively. Thank you.
Thank you, Chief Justice Carey and Chief Justice Vaught. Buenas tardes y bienvenidos. Good afternoon and welcome. My name is John Bello, and I'm the incoming court administrator for the Massachusetts Trial Court. I work in partnership with Chief Justice Carey. As a court leader, and personally as a person of color, I am committed to improving the experience of every person who comes through our doors and interacts with our legal system. I am especially committed to ensuring that we improve the experience of people of color, as we know our system has fallen short in this area. Tonight is an opportunity to ensuring that we improve the experience of people of color, as for you to tell court leadership about your experiences and to share suggestions about how we can improve. It will then be our responsibility to identify the ways in which we could address the concerns raised today. We're committed to getting this right, and we will need you to be open to tell us what we need to hear in order to make the right changes to our system. Muchas gracias. Thank you.
So thank you, Chief Justice Budd, Chief Justice Carey, as well as Court Administrator Bello. My name is John Lang. I'm the Chief Experience and Diversity Officer for the trial court. And I thank all of you for being here today, as it is really important that we hear from you, the community, about how we serve you. In terms of ground rules, we really want to make this most effective. And one of the ways that we get to do that is we ask you to speak in the first person. As much as we're asking you to share your experiences with the court, we're also asking you to share solutions. And the most responsive solution would be to someone who had a firsthand experience with our judicial system. Be respectful to everyone in time limitations. We have currently 387 people participating on this call right now, with over 500 people that registered. So the numbers may get even larger with us today. We want to hear from as many people as possible. So we've limited speakers' time to 2 minutes. I know that's not a lot of time, but we do want to be respectful to everyone, and we want to give everybody that we possibly can an opportunity to share with us today. We're also going to limit the amount of time that our panelists have in responding to your concerns, questions, or comments, just to ensure that availability. We will end at 7 o'clock. We started on time and we intend to end on time. And therefore, we will at some point limit the availability of people to come forward and speak. In terms of boundaries for the conversation that we're going to have today, we cannot discuss specific cases and/or ongoing cases. It will be really important that you do not raise those. We did get some pre-questions about ongoing cases. We will not be able to respond to those. We will not be able to provide you legal advice. So questions like, what should I do, will be difficult for us to answer to you. We can provide informational responses to you. We ask you to please focus on your experience with the court system. We are here to talk about our system. We are not competent in our ability to speak to police, prosecutors, defense attorneys, and other systems that you may have been interacting with or interacting with. Please make your comments general and do not identify specific individuals. We want this to be a productive conversation, and we want to ensure the fairness of our system by speaking in general terms, but to specifics of our personal experience. We will make our best efforts to respond to all questions and attendees. Of course, we may run out of time here today, but we will provide you with opportunities at the end of this session if your question is not responded to or we're not able to reach you through the process of you engaging in this process. We will answer those questions and make those answers available to you at a later time. I'd also like to introduce Attorney Sharice Perry, who is the co-director of support services for the court. She will be helping with the moderation of this program tonight. I'd also like to introduce Pavitra Chari and Jessica Roman Alvarez, who will be providing the administration support for this Zoom meeting tonight to ensure consistency and continuity in our process. And with that being said, I'd like to invite Jessica to share how people will participate while we are engaged with them this evening.
Thank you, John. So good evening, everybody. I'm going to help walk through how to participate in today's session. We have two ways to participate, the Q&A as well as the raise hand. So if you are on a computer as well as a tablet, at the bottom of your screen, you should see a Q&A icon at the bottom. You can tap on that And you could submit questions, testimonies, concerns that you'd like our panel to see during the session, and we will be monitoring that and floating the questions to our panel. Again, we will try to answer as many as we can. If we might also provide some resources in the chat as well, if individuals or if a panelist does identify a resource to help answer a question. Additionally, if you'd like to speak live during the event to our panel, there's also a raise hand option. You can tap that hand and it should light up and it will identify you on our end as somebody that would like to speak. Please keep your hand raised as it will give us a cue to let us know who raised their hand in what order, and we'll try to get to as many as we can this evening. Again, at the end of the session, we'll identify an email that you can use if we are not able to get to your questions tonight, or if you'd like to follow up with us in another way. And with that, I will hand it off to Cherise Perry.
Good evening, everyone, and thank you all for being here. As a means to moderate this evening's session, I will identify your name fully prior to bringing you into the room to ask your questions so that you can prepare. In addition, I will also call out the individual questions so that those questions can be provided to the panelists in which they will answer. I will also be the silent voice behind the screen that will also remind you of your 2 minutes and give you an opportunity to close out. As Jessica mentioned, if we are unable to get to all attendees this evening, at the conclusion of tonight's event, we will provide an email address so that you may ask your questions. Our intent is to get to as many questions as we possibly can, keeping in mind that this is a conversation and we will not only hear from you asking questions, but also from our chiefs in terms of responses. Thank you all for being here, and we look forward to starting this evening's program.
Thank you, Attorney Perry. Do we have someone lined up for a live question or a written question?
Sure, we had a number of questions that came in very early on, but I will invite Judge Edward Ginsburg in to start us off with the first question.
Judge Ginsburg, I'd ask you to mute yourself, and if you're willing to share your camera, and please ask your question.
Thank you. What is the court system doing about the problem that wealthier, and they're mainly white people on the civil side, are opting out of the public courts and going to private forms of resolution? It's like what happened with urban public schools when the more wealthy people opted out, and you couldn't hold in people who, if they had stayed in the public schools, would have helped. Here they're opting out of the public courts. What are you trying to do about that?
Okay, thank you. Do we have a chief that'd like to respond? Maybe Chief Abercamp?
So Judge Ginsburg, it's very nice to see you. I think the question is, if I understand the question correctly, it's directed toward businesses and individuals who go to alternative dispute resolution providers, particularly in the private sector, people who can pay private alternative dispute resolution providers. And often they do that for a number of reasons. One reason is privacy, which the court system cannot offer. But the private sector alternative dispute resolution system can offer privacy. It can also offer the parties control over scheduling more than the court system can offer. We in the Superior Court particularly in the context of the pandemic when we've not been able to do jury trials, we have come up with a whole array of alternatives so as to try to offer to our civil litigants a set of options. So we have judges doing case settlement conferences. Our judges have had training in case settlement conferences so that they can do that effectively. We are offering trials to a 3-judge panel for cases, for civil cases at the option of parties and litigants. We have always offered jury waived trials, and I think a lot of parties have chosen to take advantage of that in this time. We have recently developed a new program through the generosity of the American College of Trial Lawyers to do mediation, to do conciliation without charge for parties in any case. So that's available regardless of the resources of the parties. We also have a group of retired judges who have been doing mediation, again, without charge for parties, particularly for parties who are not able to afford private dispute resolution. So we've tried to offer an array of options so that the court can meet the needs of civil litigants even in this time. So I hope that addresses your question, and thank you for the question.
Thank you. Attorney Perry, do we have anything else?
Yes, we do. One question that we have that came from the audience is, how is the trial court encouraging and monitoring hiring efforts within the departments? Specifically, what is the Human Resources Department doing regarding job descriptions, performance evaluations to increase hiring goals and results?
It might be a John Bello question.
Yes, Court Administrator Bello, would you like to answer that?
Sure, absolutely. Thank you. And that is actually a pretty good question, as we are in the process of revamping our human resources efforts and practices, focusing on revising job descriptions and to ensure that they're not adversely impacting any group of people. We're also working to create a diversity recruiting plan within Human Resources Department, and we are in the process of working on that. As we speak, we just launched a request for proposal for training that is going to equip our managers on how to properly do interviews, panel with an eye towards diversifying pools and ensuring that we get the right people at the table. So there's a lot of efforts going on in the areas of human resources. And I think within the next 2 to 3 months, we're going to see a lot of improvement on that area. Thank you.
Administrator, would you like to speak to the talent acquisition team?
Absolutely. Human Resources recently created an talent acquisition team, and their focus is to work with each hiring manager to ensure that we're looking at diversity of the courts where the posting is occurring or they're looking for. And we're providing managers with statistics on not only census information, but the diversity of the court in general. So they are giving managers kind of the white glove treatment in ensuring that they're doing the right thing, has the right interview panel, and again, all efforts to ensure that we are increasing diversity in the right places in the organization.
Thank you.
Great.
Sharice?
Great. So we have attendee Gabrielle Chong, who we would like to promote into the room.
Excellent. So Gabrielle Chong, is that correct? Is that the correct pronunciation?
Yes, yes. Thank you so much.
Excellent. Would you like to share your question, comment, or concern?
Sure. So thank you for all the judges. My name is Attorney Gabriel Chung. So I practice primarily in the probate and family courts, and I identify as an Asian American, as an immigrant to this country. English was not my first language, so I know very well of the immigrant experience. I have been practicing in the probate and family courts now for the past 14 years or so. The probate and family courts, I think, is one of, if not the most, probably highly emotional and charged courts in the Commonwealth, simply due to the subject matter that the court is being asked to adjudicate on a daily basis. And I have seen what I perceived in some instances to be unfair and racially disparate treatment of Asians and other minorities in the courts. And I'm not saying it happens in every case involving Asians or other minorities, and I'm not saying it happens all the time. But at the same time, I am also by no means any bellwether for all Asians in the court system. But in my limited role as an attorney represented litigants in the court, if I see it, then it's probably an issue that's probably a little bit wider spread than I can personally attest to personally. Some of the examples that I personally seen or experienced, I wrote down, I named 3 of them, is I remember once there was I had a litigant that was conversationally proficient in English, but perhaps because they weren't as articulate as a lawyer would be, and due to fear and stress of simply being in court, was not as articulate as the court would demand of them at that time. The litigant was rudely cut off, and an interpreter was forced upon him without asking if he actually needed one, and his hearing was simply postponed. I've had another instance where the court inquired of litigants, and in this case, it was actually someone who spoke Spanish, to explain back to the court the meaning of merger and survival language, instead of asking litigants if they understand that certain provisions in their agreement can be changed and what can't be changed, as normally would be customary. The court curtly asked the pro se litigants to explain technical legal terms back to the court in what I can only perceive as sort of an effort to embarrass the litigants. I'm not sure. Maybe the court was overwhelmed that day, but whatever the reason, I certainly felt the embarrassment. It was palpable. I've also had the probate and family court not understand or—
Pardon me, Attorney Chong. You've reached your time. If you can conclude shortly, that would be greatly
Sure.
appreciated. Sorry.
Yeah, I'll be really quick. So I've also seen the courts sort of not understand how familial structures might sometimes work in immigrant communities and Asian communities, whereas many Asian families delegate parenting duties to grandparents and such. I've had the court sort of belittle that and neglect that and say that parents are not providing primary care, and that's kind of disappointing. So one of the most important solutions I guess I have for the bench is to have the bench clerks and AJCMs reflect the demographic of the people that come before them. When you're an immigrant or come from a country where there is a distrust of government, how can the court expect litigants to be forthcoming and trust the courts when the bench and the people that they deal with in the courts do not look like them? So my last suggestion is I think that the court should be releasing demographics and statistics of the bench and employees of the courts every year in its annual report in their ongoing effort for diversity and inclusion. Thank you so much.
Thank you. Judge Casey, would you like to respond?
Yes, thank you very much, Judge Kelly, and thank you, Attorney Chung. Attorney Chung is one of the attorneys who, whenever he cites a concern, always has a possible solution and recommend. And I appreciate that greatly, Frank. And I think that, as you know, the probate and family court, the judges make all the decisions. There are no juries there. And so the key, I think, is for us to educate the judges. You talked about a few different things here in terms of implicit bias. We have to educate people, especially judges, because most judges they make decisions based upon their gut and based on what's heard, and who have been trained that you can't do that. You can't stereotype people. That leads to unjust decisions that are being made. And so we're working on that along with John Lang in terms of that type of training. You have to dig deep. Judges don't want to admit that they have any bias in making decisions. Again, we're working on that. In terms of the cultural appreciation, again, I think we need the help of the bar associations to reach out and help to educate the judges. Judges come from all different backgrounds and life experiences. And frankly, we admit that we do not reflect the community that we serve, whether it be the bench or whether it be other court staff. But in the probate and family court, especially the bench, we have a real lack of diversity there. And we've been trying to work with the Judicial Nominating Commission to identify attorneys that would increase our diversity and to provide them some mentoring and some support that they may not have. So again, I appreciate your concerns, and I pledge to continue to work to address them. And I thank you for your question.
Might I make one comment, which is that Attorney Chung, we do provide a diversity report every year that does provide the demographics. So if you take a look at that, you'll be able to see year to year if we've made progress. So you can actually say, I think this is our third year, John?
Fourth year.
Fourth year. Okay, fourth year. So you can see over the years, we've made progress, as I think John said earlier, that we've made some progress, but not in perhaps the areas that we wish to make progress in.
So hopefully in the chat, you'll see a link to that report if you have access to the chat. Otherwise, you can find it on mass.gov.
Thank you, Counselor. Sharice, do we have another question?
Sure, we will take a question from the Q&A section, and it is, given the results of the Harvard study, what are the trial court departments doing to reduce the disparate sentences and dispositions for people of color in Massachusetts? And as a potential solution, other states like California have proposed and adopted resentencing as an option. Is that being discussed in Massachusetts?
Maybe Chief Dawley and Chief Carey?
Chief Dawley, you want to start off?
And Chief Aberkan, you may want to weigh in as well from the Superior
Yes.
Court.
Good evening. Thank you for the question. The Harvard study was informative in a number of different aspects, most notably for the evidence of the disparate sentences. But to me, it also was really instructive in terms of our future, in terms of gathering and studying and publishing data on all of the critical issues in the criminal justice system, including bails, dangerousness hearings, probation, detention matters, and sentencing generally. So I think there's a great deal of work to be done. That study was disseminated and studied widely, I know, in my court, in the district court. And I think people have recognized, judges have recognized, and clerks, that it's an important, it's an extremely important issue for them going forward in terms of seeing how we can improve and reducing and eliminating disparity in our system.
And I would add to that I think the Harvard study didn't really tell us something that we didn't really know existed. I think it's the beginning of this effort, because if you read the report, it has data from 2016 to 2018. So there's a whole lot more work to do. We now have the district court and the Boston Municipal Court. The data is available so that we're able to collect it. The Justice Reinvestment Commission is moving forward. And I know one of the major initiatives of Chief Justice Budd is to shore up the data that we have across the justice system, not just criminal justice, but justice system globally, including other of our justice partners, because data will help us manage, will help us be able to identify the areas where we have gaps and where we should be placing our resources to address the systemic racism that really exists within our justice system.
Thank you. Would Chief Justice Budd, Chief Justice Fabricant, or Chief Justice Ronquillo like to add anything? This is a big topic, the Harvard study.
So I would just say I agree with everything that has been said about this so far. The Harvard study, I think, really brought home to us, again, not that we didn't know it before, but really brought home to us the effect of mandatory minimum sentences for certain offenses. The study attributed the disparity largely to initial charging decisions, particularly where the initial charge is an offense that carries a mandatory minimum sentence, so that then the negotiation around that charge is leveraged by the mandatory minimum sentence. And that's something we've been aware of, but the study documented it to an extent that we weren't able to do before. I think it's important that we update that information. The 2018 Criminal Justice Reform Act did change the statutory landscape to some extent, and it's important that we see what effect that change may have had.
And I would just, I'm sorry, I would just say that this study has given us an opening to really take a look at the data, continue to gather data, and be able to actually see what's going on and then take steps to fix things. So.
And I think one way to look at this study is a starting block. It doesn't say anything that I think we didn't think about. This is, I think, a good foundation. Again, the data needs to be updated, but at least it tells us where we have to start. It's a look in the mirror to say we need to address these issues. It's a reality, but I think that we're not surprised. I'm not surprised by what it says, but I think for us as a system, it's a great starting block to see this is the reality, and then kind of plan how to alleviate those concerns that the study raised.
Thank you for all those responses.
Sure, I am going to promote Kendall Petty to ask their question.
Hello.
Hello, Kendall, if you're comfortable with sharing your video, if you don't mind sharing and asking your question.
This machine's acting up. Okay, so yes, unless you want to read it from the questions and answer, I have it on the questions and answers also. I prefer it to be read, if you don't mind.
Sure, I can read your question.
Yeah, absolutely.
Harry?
Sure. So do you think young Black males have a chance in the courtroom? Why is it okay for white police to come in to the court and be ready to lie on Black men just to make sure they are found guilty, knowing they are innocent? So I say, do young Black men have a real chance in your court system? Even the judges let the police get away with it. Most men are afraid to go to court because they are afraid they already know they don't have a chance. I have a son that is 19 and I am afraid for him, but I will say that lots of things have changed in the courts, but could do better. And we do have some judges that will listen to defendants.
So do we have a panelist that would like to respond to that?
Petty, may I respond? As a person of color, I appreciate your question. When I was a young practicing attorney, I experienced some things that I wouldn't want other attorneys to experience. And I felt what you feel. But I tell you, as chief, seeing the judges that are on the bench, seeing these events, I tell you that we are committed to changing this. That what you tell your son is what we want everyone to believe, that you will be treated fairly. We're far from perfect. We're human. On the other hand, we need to see the reality. And the reality is that there's some things need to change. And it's questions like that that are very uncomfortable to hear, but they're true. And when you ask this question, you need answers from us. And my answer, and I think the rest of us as a trial system, our commitment to you is to make sure that your son knows that no matter what color his skin is, no matter what language he speaks, or any other difference that he has with others, that he will be treated justly. He will be treated fairly. And at the end of the day, that skin color means nothing, that the case is treated on its merits, and that's all, nothing more, nothing less. Things are changing. We're not where we were. The fact that you're talking to us, I think, is something we haven't done before since last year. So that demonstrates, I think, our commitment as a trial system. For you to ask this question and not just be blown away and say, I forget it, but to say, you're right. The perception in the street is that you will not be treated fairly. But I will tell you that we are making every effort to make sure that that perception changes. And that is by having a reflection, by having these very difficult conversations with my peer judges and people in the court. You know, and to have these conversations and educate them about what it means to be a person of color and why people feel that way. So to answer your question is, will a Black young man have a shot in our courthouses? The answer is yes, sir. We are committed, not just to a shot, but guaranteed fairness, guaranteed justice, regardless of skin color. Again, it's a process, a long process, I admit, but let me tell you, it's these steps that we're taking that's causing us, the system, to reflect, and then to get recommendations from other people. Say, you know, what is that we need to do to be able to get to that point where we know that when people walk in, that those people know it's not just perception, but it's a knowledge that they will be treated fairly. I thank you for your question, and I know it's a difficult question to ask, but I appreciate your honesty and your candor. Thank you for your question.
Can I ask a question? Again, this is the type of work that I do as a counselor, substance addiction, behavioral health, also partnership with a program called Fathers Uplift. You know, I go to court around Massachusetts a lot, and all I see is favoritism towards the system, towards the police. And again, a Black youth, it just seems like they don't really have a chance half the time. You know, and something should be done about it. Again, when you get these lawyers, you know, court-appointed lawyers, half the time they're not even willing to put in the work, put in the time. They don't send investigators out trying to investigate what's going on, you know, and it's kind of sickening. You know, we don't came so many years, hundreds and hundreds of years, and it's still the same thing. You know, but again, like I did state, I have seen things change for the best, and I'm really happy for that. I really thank you guys for that. But again, you know, so that was just a question I just wanted to put out there. I talked to my children about it, and that was kind of the question that they wanted me to ask. Me and my 11-year-old son, which is right here, we put that together. So yeah, so that's just a question we wanted to ask.
And he needs to know that that we are a fair system. And I appreciate you bringing your young son into this, because he needs to be educated on the system. We are the good along with the bad. You know, we are not a perfect system, but it is our endeavor, it is our commitment to you and any other court user that this will change. We will move the needle forward. I'm not saying we hope, will move the needle forward. That's our commitment to you.
I'd just like to add that we've done a lot of training to help our judges and court staff be able to recognize and step up when they see something wrong, and to be able to have the difficult conversation. So we've done a lot of training, and we will continue to go out into the community to listen to community members like yourself, because it's not enough for us to believe our system's fair. You have to believe our system's fair. You have to perceive that the system's fair.
Amen to that.
Thank you
Can I
very
just-
much.
Can I just chime in? Mr. Petty, I have 2 sons myself. I have the same concerns you do. I hope that, I'm glad to hear that you have seen some change. And I hope that you think, or that you can see the people here, the judges here, are committed to making change. So we're, in that way, we may be a step ahead. We are here because we want to see that change happen. So thank you for that question.
Thank you, Chief Justice.
You, Sharice, next question.
Or I'm going to
Thank you,
ask.
Mr. Petty.
Sure. On a question that remains in the juvenile court, it was provided by Tanisha Stephanie, who is the executive director of the People's Academy, which is a nonprofit community organization involved with training for at-risk 18 plus in the Boston in trades, particularly copper trade. And there's a question about reentry programs and how can this particular organization be part of reentry programs, particularly for those at-risk youth who obtain new cases. So this particular question refers to perhaps the juvenile court.
Great. Well, good evening, and thank you all for being with us, and thank you for that question. The strength and the focus of the juvenile court in any success or change and transformation truly comes from community collaborations. And the juvenile court is committed to working with each of our stakeholders in child welfare and juvenile justice systems to provide those opportunities for youth that re-enter the system, youth that are in the system, youth that have crossed over from the juvenile justice, from the child welfare to the juvenile justice system. So what the juvenile court has done is partnered with a number of our community agencies and our community stakeholders in determining what resources exist county by county, and to determine where the gaps are in counties to support young people and reentry, support young people with substance use disorders or mental health issues, or food or housing insecurities. But it takes a community effort in order to achieve that. And we are fortunate to be able to partner with our Department of Youth Services, with the Department of Children and Families, and particularly educational services and community advocates in ensuring that those resources are in place county by county. We're growing. Often it comes down to resources regarding supporting a particular resource in a community, but we are committed to diversion and in keeping youth out of the system and providing that those services are offered and available. It's a challenge. It's a challenge. It's one that we continue to advance and promote as we work with our communities. But we look forward to advancing those needs, particularly in that age group of that 18, 19 and beyond. So thank you for that question.
Can I just jump in here quick? Yeah. This is Ed Dolan, I'm the Commissioner of Probation. So just as a practical matter, if you reach out to our office, we'll make the connection, and we're always looking for resources. And so we would partner with you, find out more about what you do and how you do it, and partner with you in your catchment area. So just as a sort of practical add-on to what Chief Justice Necton was saying, that if there are resources out there, we want to make the connection, and so I offer you that opportunity.
Thank you, Chief Necton and Commissioner Dolan. Next question.
Sure, we have a question from one of the attendees. I am going to promote Anderson Felt.
Anderson, would you like to turn on your video or not?
And unmute, please.
yourself.
Hey, how you doing?
Doing well. How are you?
Okay, hold on. I was right in the middle of something. I'm sorry.
Would you like us to come back?
Okay. No. Hold on. Your video is stopped. I don't know why.
We can hear you if you want to just ask your question. Now you're muted.
Mute. Okay. Let's just start your video. Okay. All right. So basically, first name is Anderson, last name is Felt, and I'm a Haitian background, American, a citizen American. So basically, I've graduated since 2012, and then from that point, you know, I already had on my mind that I want to become a probation officer. So I went to all the steps to become one. I even try to, I even went through the whole process with the court officer just to get my foot at the door, which that, I remember that the chief court officer told me that, we had an interview, went through the whole process, and even the physical ability test that I went through just to get my foot at the door. And I passed the exam for the court officer. And then, I went through the whole process basically. So, and I was stopped basically over something for me silly. They claimed that, my reference didn't call. So, all right. So from that point, I remember I had the interview with that chief probation officer. It was me to 6. I'm not gonna reveal no name, but anyhow, that I guess, I'm a type of person that speak up my mind, and for some reason I notice people don't like it, but for some reason I was knocked off for the court officer, which I went to 2017. I went to take probation exams too, which I passed it. And I haven't heard nobody, and I kept on calling and calling, and I know the criteria, which another thing that I want to raise raise something about it. So the criteria, you have to have at least 6 years, I believe 3 or 4 years. I'm not sure. It's not, it might not be accurate what I said, but a guy that graduated that wanted to, proceed, become a probation officer, and it got the criteria with it, and then
Mr. Phelps?
Yes, I just want to know, like, what makes it, like, what are you guys gonna do as far as hiring process, because it's kind of the hiring process is it kind of knocked off some people that really want to become something they will love to become. So
Thank you,
I
Mr.
just
Phelps.
yeah.
I'm going to turn to John Bello.
Thank you, Judge Kelly. Thank you, Mr. Feld, for your question. I think, as I indicated earlier, we're in the process of, on the human resource side, working at revising our policies when it comes to hiring and ensuring that we're intentional when it comes to diverse hiring candidates. So that is work that is ongoing, and work, as I indicated earlier, we hope to see the fruits of that labor come to fruition within the next 2 to 3 months. This is work that is ongoing, so more to come, and we appreciate the question.
Commissioner Dolan, do you want to add anything to that?
Sure. Yeah, it wasn't sort of clear from Mr. Felt's explanation exactly, where they got off track. But we would, again, if he calls the office, we'll be happy to do that. We know that there's a, bureaucratic process, take the test, fill out the online application, and that's really how people come onto our radar. And then the screening process is from there. But we're happy to help get people through that process. We know that that can be complicated and challenging, so we're certainly willing to do that. I'd make the offer to, get in touch with our office, and we certainly will have the staff that will walk them through that and support them through the process. So thank you for the question.
Yeah, thank you, Commissioner Dolan, and thank you, Mr. Felt.
Great, thank you. So we have a question from the Q&A section. This was raised by Virginia Benson. Language access is always of vital importance, but even more so now during the pandemic. When limited English proficient individuals cannot physically go to court, although the Massachusetts Trial Courts has a language access plan and the Language Access Advisory Committee, the court is far from providing language access to LEP individuals who encounter the court. The language access plan, which has not been updated since 2014 and by law must be updated every 2 years, is not being uniformly implemented by the courts across the state. Office of Court Interpreters, now Office of Language Access, has protocols on how LEP litigants can access an interpreter, but clerks' offices are not aware of these protocols, and LEP individuals in need of language access are being turned away by the court. Housing court specialists are being used as interpreters, which is a conflict of interest. Training and education to court and clerk office staff to effectuate change. Is this in the funding?
Thank you. Chief Carey, would you like to take that? Or Chief Sullivan?
You're on mute, Chief.
Yeah, I can speak to certainly the housing specialist piece of that question. And I certainly can share in the frustration that I think many of us have dealt with when it comes to not only getting an interpreter scheduled for a particular hearing, but also the frustration that comes about when the interpreter doesn't show up for some reason or another. We've seen less of that in the age of Zoom, thankfully. And I think a big part of that is not just Zoom, but the effort that's been going on at the Office of Court Management under Chief Carey's leadership to expand and improve the level of service when it comes to interpreter services. With respect to the specialist, the housing specialist, by the way, which we commonly refer to them as mediators, we have a staff of mediators in all of our 6 divisions. Very often, and we put a great deal of emphasis on diversity in hiring. And one of the things that we think about when we bring a housing specialist on is some of these real positive attributes like bilingual factors. So we will oftentimes use the specialist only if it's agreed to by the parties to help move a case forward. And that's usually done in the context of mediation. And so we do have some frustration dealing with this issue. I have to say it's a real issue. We understand it, and we are taking, I think, some very measurable steps to address it forthrightly at OCM. But again, I think it's we try to just triage these cases and treat them with a great deal of care up front. And if the parties agree to it, the specialist will help to communicate the matter in the person's preferred language.
I just want to say before you go, Chief Carey, that OCM is the Office of Court Management.
Thank you, John, and thank you, Chief Sullivan. Thank you for the question. I think it's an excellent question, and you raise really important concerns. We just recently published standards for our interpreters, which I think is a big step forward in terms of providing the possibility for them to get certified so that we have the highest quality that we can. And we're incrementally getting better, but we're not where we should be. We are soon to have scheduling software that I think is going to help tremendously in terms of making sure we get interpreters to where they need to go. During the pandemic, it's been difficult. Some of our per diem interpreters have not been comfortable going into the courts. We've had to do it remotely. So it's been a challenge. We hope post-pandemic, it will become much smoother. But it's an area of progress, and our department has reorganized itself to the point that we're certainly getting some traction at this point.
Thank you, Chief Justice Carey and Chief Justice Sullivan.
Can I jump in just to add a little bit more to that question?
Absolutely.
If you don't mind. So Chief, I would like to say that the good news is we do have the scheduling software in place. So that is definitely improving the delivery of services to the field. The office continues, even during the pandemic, to try to recruit per diem interpreters with an eye towards certified interpreters. And there's a lot of progress happening in the office. And I think that as Chief Justice Sullivan indicated, it used to be constant that interpreters were not showing up for court events, but we have improved in that area. And we are committed to continuing improving on that as well.
And may I just add a little bit myself, please? As chair of the Language Access Advisory Committee, you're correct. The update is late. We've been working on it. But as it relates to the to interpreters in every courtroom, every courthouse, every clerk or register has a language access liaison, or should have, in every court, so that they are the contact person to contact the Office of Language Access. I know that they've hired many people the last couple of years. Again, I think to your point, Ms. Benzan, we're not where we are, but I think that we definitely have to improve the access to the LEP, limited English proficient individuals, because it is a very, very, it's a dire need. The languages are expanding. Signage is one thing that we're working on as well. Forms we were looking at, there's a whole host of things that we need to address, and we are addressing. It's a work in progress. And it is our hope that, my expectation this year that the plan will be reviewed again this year and updated, but know that there is definitely focus being placed on this every day, and that we want to make sure that that the court you visit has that language access liaison, who is a person, as I understand, in charge of contacting the Office of Language Access, in order to make sure that whoever the court user is has an interpreter available. Thank you for your question.
Thank you. Attorney Perry, how are we doing on time? We're at that halfway mark, and I noticed there are a number of raised hands and many questions. So what do you think?
I think we're doing okay for now. There are a variety of questions that can be consolidated. So there are a number of questions about the SJC well-being. Attorney Chung expressed concerns around attorneys of color practicing out of the probate and family court. And so I'm going to promote Attorney Thomas Bond, who has offered comments, but also has asked to be promoted to as a panelist.
Attorney Bond, when you're on, if you could unmute and show your video.
Thank you all for having me. We see this. First of all, I'm president-elect this year and incoming president of the Mass Bar. We see this serious problem, these two reports, the town hall report and the racial disparity report. It's not just a trial judge problem, but it's a problem for the trial bar as well. So I'm wondering what everyone's thoughts are on forming a committee with judges, with the MBA, and with all of the affiliated affinity bar associations, so we can come up with a solution, perhaps, to address some of these issues.
Thank you, Attorney Bond. Chief Justice Budd or Chief Justice Carey, would you like to respond? You're muted, Chief Carey.
Yeah, I don't mind responding, and then Chief, or do you want to go speak first, Chief?
No, go ahead.
I think that's part of right now, what we've, we too, Attorney Bond, were very concerned about the lawyer wellness report that came out. In fact, frankly, I think I got a copy of it on a Friday. Sunday night, I made all my chiefs get on a phone call. because it was so disturbing to me that I wanted to have a conversation about a way forward and what are the things that we can put in place. And I invited Justice Margot Botsford to participate in that phone call because she participated in many of the outreach sessions. And I should say that it didn't necessarily surprise me, because in August, Chief Justice Gantz and I had met with the members of the Black Judges Association, and the concerns they raised in that meeting really brought me to tears. And then I could see how troubled they were about the way that the things that they experienced when they were just doing their job. And so some of the things that we have done is that I believe it was that Monday or maybe Tuesday morning, I sent out a notice and sent that report to every single employee in the trial court and asked them to reflect upon it. In that if this is how people are perceiving our system, that we have a real problem and we need to address it. We recently sent out a notice to the bar associations explaining our concerns. Justice Botsford was bringing us back together with all of the affinity bar leaders. One of the things I wanted to have a sort of a debriefing and have a conversation, but I also don't want to traumatize those courageous lawyers that were willing to step up and say speak their truth and in terms of their experience. So so that is a work in progress, but I think it's something we collectively need to do because, and it has to include law schools, not just, we've had a problem with getting and trying to get lawyers of color really kind of interested in the bench and interested in clerk magistrate positions. So, and to really get them start thinking about it from the minute they're in law school and to begin doing things to set themselves up. The other thing that folks should know is that our discrimination and harassment policy is not just for our trial court employees. The main reason for us getting the notice out to the bar and others is that discrimination policy protects you. It protects lawyers, and it also protects the public. So we've put out the email address for folks to call if they have a concern. And since that notice went out, we've had a large uptick in our Office of Workplace Rights and Compliance. There's been a lot of people who have communicated with that office. So those complaints will be investigated and will be looked at. But that's just a piece of it. I think this is a collective issue. So, Chief?
Yeah, Tom, thank you. I think Chief Justice Carey pretty much covered it, but as you point out, it's not just a court issue. And certainly here in the Massachusetts courts, we are committed to changing the culture that allows for people to not be treated well. That's unacceptable. It's absolutely unacceptable. And we have to figure out how to change it. So as Chief Justice Carey pointed out, the Standing Committee on Lawyer Wellness is working with the affinity bars because we need help trying to figure out how to change this, right? And we are looking for, we're going to work here in our system, but we got to figure out how to get at it in a lot of different ways. So we are open to suggestions, and to the extent the NBA wants to give us some help and support in that way, we'll take it.
Okay, thank you.
Thank you, Attorney Bond. Attorney Perry, you have another question or comment?
Sure. So on the topic of judicial accountability, We have a few questions in the Q&A as well as questions that were provided prior to. There is a feeling that judges are never held accountable when judges say inappropriate things that go beyond the types of things we are all mistakenly say what happens, unless there's some sort of indication that people will be held appropriately accountable, then it all feels meaningless, whether to professionals, litigants, or the public. Many times attorneys and others of color who are marginalized or underrepresented groups do not speak out on the microaggressions or bias issues that they or their clients experience, often due to fear or concern of retaliation on either case or long-term basis. What is the court system's plan to build safety measures, means for attorneys and others, as well as how will the public and others hold judges accountable, and what steps can they do?
Chief Carey, would you like to take that one?
Sure. I mean, I can describe, thank you for the question, for whoever gave that question. We have judicial evaluations. That's one way that you can certainly raise issues with regard to a judge. I can assure you that we have a robust, although our judicial evaluations have been on hold because of the pandemic, because of the stilted sort of nature that lawyers are communicating with lawyers and others. The public are communicating with judges. But once we expect to get back, we do take the judicial evaluation seriously. Judges sit down and go over individually each evaluation with their judge, and requires judges to come up with sort of goals and objectives, performance plans. We have a very robust judicial mentorship program. The first 2 years of a new judge's tenure, they are required to have a judicial mentor. We also have a mentoring program, a piece of it that is for judges who are struggling with something, or a judge against whom a complaint has been filed. We have a process for complaints against judges. They are investigated by the chief judge, or sometimes the chief justice. Sometimes the chief justice may pass that off to our to have someone else investigate it, which may be our Office of Workplace Rights and Compliance. But that is in the discretion of the judge. We take complaints seriously. You know, public trust and confidence is important. It's important to each and every one of us. And so that if there's a time where a judge has lost their temper or said something inappropriate on the bench, we need to know about it so that we can have a conversation. Sometimes it's not to, you know, I mean, sometimes it's not to discipline, but it might be to have a conversation and find out what's going on, and to try to help that judge. If you believe it's a legal decision where someone has made an error of law, well, that's where appellate courts, that's where it has to go, to the appellate courts. But if it's a temperament issue, if it's you feel as if there's been disrespect, we heard earlier today of sort of disrespect, microaggression type behavior. We're doing a lot of training, but you need to let us know. You can report it anonymously if should you wish, on the hotline, or to a chief's office if you believe that on a consistent basis. It might involve a chief or someone like John or someone like Maggie Pinkham, who is the head of our Office of Workplace Rights, that have a conversation with that judge and educate that judge about what they might be saying. I understand the issues of fear of retaliation, but if I did something, I'd want to know. I hope we get to a point that all judges can be introspective, and all court personnel for that matter. It's not just judges. I'm sure that some of you may have experienced some of our court personnel say something that may have been inappropriate, or you felt harmed by it or pained by it. And I think it's up to us to develop and get to the point where we have a system where we can have these difficult conversations and really be able to raise it and say, you know, that hurt my feelings and here's why. So I hope that answered the question. Did I miss any piece of it? That was kind of a long question.
I
Thank
think
you.
you hit each of the points, Chief.
Thank you.
Attorney Perry?
Sure. So I am going to promote Lisa Wagner to the panel.
So Lisa, if you could unmute and share your video if you are inclined to.
Hi, I'm having a little bit of technical difficulty here.
There we go. We can see you.
Oh, sorry.
And
Yeah,
we can
I'm
hear
having
you.
a little. All right, great. I don't know. One of the things that I've been noticing and hearing some of the people from the public talking is, you know, that as a public defender myself, I sometimes hear, you know, people talk about how, you know, we don't, you know, really represent the clients, or that we're just another piece of the puzzle in sort of the institutionalized system. And I think sometimes it's really hard for to see how we look to the people who are using the court. You know, when our clients come in, we see, you know, they see us talking to the defense and the prosecutors, or to the court staff, or to court officers, and it's sometimes hard to see, you know, who's working, you know, who's on their side, if you will. And so I think that's true in particularly for people of color, because, you know, the system's already rigged against them. So I guess one of the things that I believe it was Mr. Felt's question, maybe, that, you know, that people who come into the court often, like police officers who are known to the court and things like that, who aren't necessarily court personnel, but are known to the court, how, you know, we can encourage them and ourselves to be more aware of how we look to the outside world, or to the court users.
So thank you, Ms. Wagner. Does anybody want to respond to Ms. Wagner?
I'm happy to respond.
Yeah.
I think that it's probably, again, about conversations. I think we need to all be mindful of what we do and how to make people feel that we represent, feel comfortable. And that I think, you know, the judge needs to be mindful, defense counsel, prosecution all needs to be mindful. And maybe it's probably the role of the defense lawyer to have a conversation with the client and say, you know, you may see me go over and talk to the prosecutor. And I don't want you to think that I'm not on your side because I go and I do that. I do that because I have to have a conversation with him. And I know as part of that lawyer well-being report, there were conversations about, and it even happened to lawyers, which is that, you know, the more friendly you are with the court personnel, people on the other side, and if it's not the person next to you, that's being really friendly with with court personnel. You know, I think that being the more as transparent as you possibly can be is probably the best method, and that goes for judges, that goes for court personnel, and maybe that's part of a collective conversation that we all have to better serve the people that we all serve in different ways, and to tell them why we do what we do. We kind of just do it and really don't talk about it. And I think it makes it a mystery. You know, I remember sitting as a judge, and, you know, lawyers call each other brother and sister. And, you know, people in the public think that they're brother and sister, and they don't really know the vernacular and don't know, you know, that sometimes that's not, you know, it's not what it is. So that would be my comment. I don't know if anyone else has anything to say.
I'd just like to say thank you for bringing that to the conversation, Attorney Wagner, because I think for everybody else in the courtroom, it's just another day at work. But for the people who are coming in as a defendant or as a self-represented litigant, they don't know what's going on, and you make assumptions. And I think it's just part of it could just be a matter of making sure judges are aware of how whatever they're doing may look to the defendant who's in the courtroom. So, you know, even though you may know the probation officer or you've seen the prosecutor and, every day, or some of the police officers you recognize, you still have to be really professional and keep that arm's length distance, so that the defendant doesn't think that they are at a disadvantage, at least in that way. So thank you for that.
Thank you, Attorney Wagner, Chief Justice Spud, and Chief Justice Carey. Before you give us the next question, Attorney Perry, I just wanted to make sure that everybody knows that in your chat, you should have access to the annual diversity report. You'll also have access to the Supreme Judicial Court Steering Committee on Lawyer Wellbeing that has been referenced a number of times today. You have information for our Office of Workplace Rights and Compliance. If you have a concern about how you have been treated or mistreated within the court, that is a place for you to call, as well as the trial court hotline phone number, which is 617-878-0411, if you want to address concerns of fairness and equitable treatment. You can do that, as Chief Carey mentioned, anonymously. It is also better for us if there's a way in which we can follow up with you to fully understand what is being presented to us. So, Attorney Perry?
Sure, and being mindful of the time and the number of questions that we have, just a reminder to all attendees that at the conclusion of this program, we will be providing information as to how you can reach us directly with any questions or concerns that you don't have. We will also have a website in which we will provide all questions and answers. And during the remainder of this time, we will do our best to respond administratively to any questions in the Q&A section. So I will turn this over to all of the current attendees, and we will not be taking any more after the last person in line is the last person in line at this time. So I am promoting Kathy Rebolt into the panel.
Kathy Rebolt, your microphone is muted and your video is off. All right, great. Thank you very much. What is your question, comment, or concern?
Yes, thank you for calling on me. Okay. I'm sorry, I just, I need another minute. Is there someone else who has a question?
Sure, I can, we can put you back and we will bring you in shortly. I am going to promote Sharu Verma.
Good evening, Cheryl. You have a question, comment, or concern for us?
Well, of course, I have everything, and I want to thank everyone for the opportunity to let me address such an esteemed panel. First is my comment, and I want to thank you all for not being shocked by the reports that you received. I am the co-chair of the Massachusetts Bar Association Criminal Justice Section Council. And as I've been hearing other groups talk about the report, it's very frustrating to hear how shocked people are by this report, because as we know, these are not new issues. So I'm encouraged to hear that the leadership of our trial court has already embraced these issues and that you're working on them. Last week, we actually had the opportunity to discuss the reports, and here's a couple of suggestions that emerged from the section council. And one is very simple, because I think a lot of the issues you're talking about are culture changes that are going to take years, and we can't give up. We have to keep chipping away at this. This is not an instant solution, but one instant solution would be to perhaps put signage up in the trial court that in different languages that gives the information about the Office of Workplace Rights and Compliance. The fact that I just had to look at what that title is, I think indicates that I had no idea this office existed and how to contact them. And I've been working as a public defender for 9 years as an attorney of color, and I didn't even know where to lodge a complaint like this. So I think basic signage throughout the trial court system would be very helpful. And a question that I had would be, is there room at the trial court perhaps to consider an independent civilian oversight review board that could look at the data that the trial court collects and the complaints and provide feedback to the trial court so that it's outside of the trial court, but includes community stakeholders to be involved on a regular basis in that conversation. And again, I'm not going to take credit for these ideas. This is from a working group at the Bar Association of very committed attorneys who came up with these suggestions. So thank you so much for the opportunity to speak to you all.
Thank you for that novel suggestion. Anyone like to respond?
So I'll like to respond on the signage piece. I'll ensure that we begin working on that as soon as possible.
And I guess I can respond to the Civilian Oversight Review Board. It's certainly, we're open to discussing any suggestions. So we appreciate the suggestion, and we will have a conversation about it. Thank you.
Thanks.
Thank you very much.
Thank you.
Thank you. Thank you, Attorney Verma. Sharice?
Sure, I am going to promote Stacy Forts to the panel.
Judge Kelly, I'll allow you to introduce Judge Forts.
I'm assuming it's Judge Forts. I'm going to turn on your video and I can confirm. And you're muted. So if you're ready, you can begin. Maybe she stepped away. Should we?
Sure. Sure, I will ask a question relative to the jury. Hold on one second.
Oh, I didn't see that. Thank
so
you.
there were questions about impaneling juries. What is the court doing to ensure that the makeup of jury panels reflect the diversity of the community in which they sit? For 35 years, I have been in the courts of the Commonwealth and represented indigent clients who come from different social, political, economic, and educational backgrounds than most, if not all, of the judges. Consequently, they fear a trial before a judge. They seek a jury trial because they believe that the jury will be composed of their peers. Unfortunately, when the jury selection begins, they realize there are few and often no individuals in the panel of color, or similar ethnic backgrounds, what can be done.
I wish Pam Wood was on the line, but someone like to take that. Go, Chief Fabricant, thank you.
So I think I can say what Pam would say, because I've come to know what she would say very well as chair of the Jury Management Advisory Committee. This is an area where I think Massachusetts has a tremendous story to tell and a lot to be proud of. Unlike many other states, we draw our jury pools from the municipal census. So almost everybody just filled out your municipal census form because it happens about this time of year. So you've been reminded that we have an annual municipal census that everyone fills out, and that's the source of our jury master list. We don't take it from driver's license lists. We don't take it from voter lists, all of which may be skewed in various ways. We take it from the master census. And the Office of Jury Commissioner has very robust data and a very careful system. We draw our jury pools from the entirety of each county, not from a particular city or town, but from the entire county. What that means is that the jury pool in each location reflects the makeup of the county, and the Office of Jury Commissioner publishes data regularly that shows the relationship between census data for each county and the jury pools for each county. And it's actually a very close match. So when you go into a particular courthouse and you look at a jury pool for a particular case, it may or may not be a match on that day in that case. But overall, looking at all of the data overall for the jury pools in each county over the course of time, it actually does match the census data very well. Now, in some counties, certain populations have very small representation, and you're going to see that in jury pools inevitably. In some counties, those populations will have much higher representation, and you will see that in jury pools inevitably. But overall, the data, which is published and is available, shows that our jury pools are really very representative of our population. So I appreciate the question. Thank you.
Thank you, Chief Fabricant.
Sure, I'm going to go to Carla Sheffield next.
Oh, hello. Can you guys hear me?
Yes, we can.
Yes, you can.
I know I saw on the chat that it said that you were doing more about diversity when it came to people who were applying to work in the courts. My question is more for those who are already in the court. Like, I've applied several times to be a clerk magistrate. I started off in the administrative office. I worked in Dedham, Stoughton, Quincy. I traveled. I wore many hats. And I feel like I've been looked over numerous times. And this year will be 25 years that I've worked for the court system. So how are you guys going to do in-house, like people who are already working in the courts and promoting them or giving them a better opportunity, African-American women, men, better opportunities or avenue to secure that clerk magistrate position? Because it's not for a lack of trying. I have a master's degree, but I've worked for, like I said, it'd be 25 years this December. And I went from working in civil, criminal, small claims, restraining orders to sitting in the back of the office, logging in search warrants. That's not what I want to do.
Thank you.
I'm worth more and I can do more, and I like to do that.
Thank you. John Bello or Chief Gary, would you like to respond or?
Sure. I'll begin, and Chief Justice Gary, feel free to jump in. I'm glad I was asked that question again, and that the question came around because there is some information that omitted sharing when it comes to our efforts to recruitment, diverse recruitment. And we actually have made investment, and this applies for, I think that this is an internal promotion question, but I just wanted to set the stage for what we're doing for external right now, which is we have made investments to 2 sites where it pushes our jobs to 8 different sites, diversity sites, so that we're including African American, Latinos, Asians, you name it. So those efforts is something we're putting in place for promotion within. I think that there is a lot of work, again, working with our talent and recruitment. We're looking at potential mentorship potentials so that we could help people along the way. And so we continue trying to move the needle in the area of hiring. And however, we do understand that retention is as important as bringing new people in.
And the only other thing I would suggest is that the clerk magistrate position is it's either one of 2 things, depends on which court you're in. If it's the district court or the BMC, it's a gubernatorial appointment, so the governor appoints those. So it's not really up to the trial court, other than we try to encourage and get folks to have the skills within our court so that they are able to get to the governor's office and be chosen, or it's an elected position if you're in the superior court or you're in the probate and family court and you're seeking to be a register.
Thank you, Chief Carey, for clarifying that. Attorney Perry, do we have the next person?
Sure.
Question?
Oh, Kathy has not raised her hand, but I will find her. That was the prior participant. I am going to promote Alton King.
Alton, if you can unmute, share your video. There you go.
Hello, and thank you very, very much. My name is Alton King, and I would like to thank you for this opportunity to address my many concerns as I am forced to deal with a predatory lending nightmare. In 2006, I was given a predatory loan by Community Lending Incorporated, which was the last year that they were able to do business in Massachusetts. The monthly mortgage started at $3,250 a month and escalated to $13,400 a month in less than 5 years. They also utilized an inflated appraisal of $1.5 million in order to fund a construction loan of $410,000 for an addition to the home. The project was completed in about 6 months, but Community Lending claimed that the value of the home was reduced to $250,000 in order to avoid consolidating the loan. Now, a securitized trust claims to have foreclosed on my home. Predatory loans are not allowed in pooling and servicing agreements, which means that they are not eligible to be placed in any trust. The mortgage was not transferred into the trust in the 90 days, or under special circumstances, 2 years into the Hampden County Registry of Deeds and Records. In December of 2017, they attempted the transfer 9 years too late. And 6 months before that date, they started the foreclosure procedure. The trust was not even legally executed or created. I was fraudulently charged mortgage payments by an institution that did not have possession of the mortgage. All of this is in the court record.
Mr. King,
No court.
I apologize for having to interrupt you, but you have met the 2-minute time. Do you have a question that you would like to ask?
My question is, what can or what will be done to have basic rules, basic laws implemented? Because this is something that, as a Black person, so many people, so many of us are facing. We're not even getting the basic criminal, or in this particular case, predatory loans laws enforced, so that we will not have to deal with so many of these problems.
Chief Justice Piper, I'm not sure if you've heard everything from Mr. King. Are you in a position to respond in any way?
Sure, I can say a few words on the topic. I don't want to talk specifically about Mr. King's particular case, but the question of predatory lending is something that comes up with some frequency in a number of our courts. It's sometimes raised, and I think the idea is that it's raised at the wrong time in the land court when the case has already progressed to a point where a foreclosure is imminent. But there are a lot of cases, including some out of the Supreme Judicial Court, that try to afford protections against predatory lending. And there certainly is a lot of assistance to be had through the Attorney General's office, through the Banking Commissioner's office. And I think those are the places to turn. In many cases, the problems of predatory lending are not properly raised once the foreclosure is imminent, but are more properly raised beforehand. And I think that the suggestion is that you take it on and try and get some help to join you in the fight. And there are some successful cases where predatory lending has resulted in invalidations of mortgages or injunctions against foreclosures going ahead. I'm not sure I want to say much more than that, but and it may be Chief Justice Fabricant wants to say something as well, because a lot of those cases, I think, do end up in the Superior Court.
Well, I think Judge Piper has it exactly right. We can't comment on any particular case or any particular loan, but there certainly is law to protect people from predatory lending. It's a very complicated area of the law, so it would be the kind of matter in which it would be very helpful to get legal counsel.
Thank you, Mr. King, and thank you, Chief Piper and Chief Fabricant.
May I add something, Judge?
Oh, sure.
Real briefly, Mr. King, that's a great question you asked, and I have to share the concern raised by my two colleagues with respect to the fact that this sounds like a specific case. So I won't get into the specifics of it with you, but I just wanted to add to this that there's been a great deal of state and federal law and regulations that have come about since 2007 and 2008, when the foreclosure crisis really hit hard. There's also been a tremendous amount of case law that's come out since that all happened. My suggestion is that the next step after the foreclosure is the potential of an eviction case that might come about. And I know that's a very difficult maze to sort of traverse, particularly for self-represented litigants, which a number of self-represented litigants come to our court in the housing court. I would just make the recommendation that if you wished to try to find some additional resources relative to your questions, we have set up in our court a virtual clerks counter and a virtual housing specialist counter. And in all of our divisions, they are staffed by attorneys who make themselves available from the community at no cost. So it might make sense to reach out to those resources and see if you can't get some competent legal advice on those very intricate issues.
Thank you, Chief Sullivan.
Thank you, Mr. King. We will put in the chat box a link to the housing court. for you to look that information up.
Sure. So there have been a number of questions regarding the criminalization of those who are impoverished, or what we would call criminalizing the poor, whether it's housing or criminal. One of the questions that was posed was, how can the court ensure that people who don't have social economic bandwidth for proper defense get the same quality representation as someone from a wealthier background? Black and brown people are at a disadvantage and often take plea deals because of the fears of mounting legal fees if they should go to trial, not having the resources to hire counsel that isn't spread thin, and belief that the system is already against them. How do we give them quality service if Lady Justice is blind?
Chief Ronquillo, would you like to respond?
Yes, the question, I think, addresses more the quality of the lawyering. And I think that, again, and I speak for myself, having been a working when I was in private practice before I became a judge, I did court-appointed cases for 13 years, the entirety of my practice. And it was important that all my clients receive the same representation, whether they paid privately or the state paid. And at the end of the day, we would hope and expect that every lawyer treats clients that way. And the question is, how do we, as a system, ensure that the quality of lawyering is similar? Well, we can. I will tell you this, that I know that there's instances where judges have asked lawyers on particular cases about whether or not they have filed certain motions when they're appropriate. A standard is set for each lawyer. The Board of Bar Overseers is there just for that. If a lawyer falls below the standard set, then there are consequences. But let's not, again, and let's be honest, is money talks. And a lot of time the people who can afford it can afford private investigators and different tests that the public cannot. And that's something that we as a system need to ensure, or need to make efforts to try to make sure that we level the playing field. There is limited funding for CPCS, who's a Committee for Public Counsel Services. They are the court-appointed lawyers for the entire state. They fund it. They have a budget, and they fight for a larger budget to be able to pay for more investigators, to get the experts. But it comes to a point where we would ask and expect, and we do see, I will tell you, some quality lawyering in the court-appointed counsel. They are, if they are not employees of the state under CPCS, they're private attorneys who represent these indigent individuals. And I will tell you that by and large, most of the attorneys who appear before us are very responsible, cognizant, and they are zealous advocates for their clients. Their pay is not what one would expect, but you can just see the zealous advocacy that they put forth many, many times. And to be honest with you, it may be a historical belief that court-appointed lawyers are not the best. I will tell you that some of the best court-appointed lawyers are some of the ones who do it every day. They fight, they take these jobs on, knowing that they're not getting paid what they could otherwise, but because they feel and they know and they believe in what they're doing. It's these indigent clients who need the best representation many times. So as a result, they take an oath and they make that choice to represent the indigent, the voiceless, because they have no money. So I think the impression that because of the court-appointed lawyers, they're not as good. Again, I would dispute that. I would dispute that, because I think many times it's these who are representing the indigent who are fighting the hardest, because their clients have more to lose many times. Thank you for your question. I hope that answers your question.
Thank you, Chief Ronquillo. I just want to turn to Chief Fabricant to give you a chance to respond.
Well, I just want to second what Chief Ronquillo just said, just the last part of what he just said, which is that some of the very best lawyers that we see in our courtrooms are the CPCS attorneys. They have some really outstanding trial lawyers trying cases on behalf of indigent defendants. CPCS has standards and training programs and supervision. And this is an issue that I feel strongly about because, and I know there are a lot of CPCS lawyers who are in the participant group observing this program and wishing they could speak up. So I want to speak up on their behalf because I have seen some really excellent trial lawyers representing indigents through CPCS. And when I would try cases to a jury and I would speak to the jury afterward, almost every time in criminal cases, somebody would say, was that lawyer appointed or was that lawyer retained? Because there is this myth out there in the public mind that appointed lawyers can't be as good. And I would always then take the opportunity to say, that was a really outstanding court-appointed lawyer doing a really good job. And in Massachusetts, we provide really excellent representation to indigents through CPCS. And I think we should be very proud of that.
Thank you, Chief Fabricant. We're going to try to get in one more question, but I see Chief Nectum just wanting to say something. So you have to keep it real brief, Chief Nectum.
I was just going to say, I can't echo enough what I just heard from both chiefs, that in the juvenile court and child welfare cases and juvenile justice cases, the passion of purpose that CPCS and private counsel that are working with CPCS, not of the Catholic Bar, are just outstanding, and we're so fortunate for their service.
Thank you for keeping that brief. Attorney Perry, we're going to take our last question, comment, or concern, and we're going to ask that person to keep it brief, or you keep it brief, and the response will be brief.
We have Kathy Riebel, who had come in before and has indicated she will ask her question very briefly.
You may begin. Thank you.
Thank you very much. My name is Catherine Poole. I'm a member of the Juvenile Justice Coalition, and I've worked in 3 DYS facilities. I'm concerned about the racial disparity in the juvenile justice system. We have the 4th worst racial disparity in incarceration in Massachusetts compared to the rest of the country. That's the 4th worst. In some counties, Black youth are 2.5 times more likely to be incarcerated for the exact same crime as a white youth. And racial disparity has actually gotten worse since the Criminal Justice Act of 2018. That's because some of the interventions have worked better for white youth because maybe more resources have gone in that direction. So this is a problem, the racial disparity. So first of all, I think we need real-time data at a local level. Second of all, there's a bill, HD 1975. Again, that's HD 1975 and SD 799. So HD 1975 and SD 799. This law would actually require data collection and reporting, and that would really give us a chance to see where the problems are. And sometimes the problems might be implicit bias. It may not be intentional, but is directly affecting the lives of Black and brown youth. And one of my concerns is once young people are incarcerated, that increases their likelihood of incarceration later, and it changes the trajectory of their lives, and it changes the trajectory, frankly, of many communities that are over-incarcerated. So without naming anybody, and this is my last 3 sentences, without naming anybody, someone in the court system has been actively advocating this bill not passed. I will not name that person. That's not my goal today, but I would ask that that person stop doing that, but also that the court maybe even consider advocating for this bill and being really open to this. It's a difficult thing, but I would really appreciate it and would be directly positively impacted on the life outcomes of Black and brown youth. And I appreciate it very much. Thank you so much for your time.
Thank you. Chief Nectum.
Yes. Oh, is it Attorney Riebel? Thank you for your question. And I wish I had more time than I had to respond to you. And I look forward to following up at some point. But just first, relative to the issue of data, the juvenile court, just so you know, I'm aware of the bill and I'm meeting with one of the representatives on that soon. But we are committed to using data so that we can understand and analyze the impact of disparities in court-involved youth. just so you know, we recently published the first virtual dashboard of case filings, which do show the cases by race, ethnicity, age, and gender. So we are growing. It's a Tableau software, so it's easily understandable, digestible. We're growing from the juvenile justice to the child welfare arena. We understand that data on race and ethnicity is very, very important. We're working with the community and with our court partners in order to share that information regarding, and I'm going to talk very quickly because I know it's 7, regarding detention alternatives as well. You know that the court is heavily involved with the Juvenile Detention Alternatives Initiative, keeping the numbers down, but also lifting the voices of those impacted youth and families towards equitable and positive outcomes. So that work continues, and we work collaboratively with our partners. So we're looking forward to sharing that data, public-facing data, and mining that data internally so that we can understand ourselves, judge to judge, exactly what's happening on our cases and understand and grow and listen further. So I know that's quick, Ms. Rebold, but I hope that answered your questions, and I will look into both of those bills, which I'm aware of. Thank you.
Thank you. And I'd like to thank all the panelists and participants and turn it over to Chief Justice Budd.
For closing remarks.
Yep. Well, I want to thank all of you who have taken time to join us this evening. And thanks to you, those of you who have taken the time to present questions and comments. We appreciate your willingness to share your experiences and to raise the difficult issues that you've raised. We also appreciate your thoughtful suggestions. Thanks again to the committee for presenting an opportunity to engage with the community. Thanks to the trial court chief justices, Chief Justice Paula Carey, Court Administrator John Bello, and Commissioner of Probation Ed Dolan for being available to the community to answer the questions that have been posed tonight. We pledge to do all that we can to solve the problems that have been discussed this evening. We're committed to making the changes in the court system, large and small, that are needed to provide justice and equity for all. With your help, we know that we'll continue to move forward and make progress. Thank you all, and please stay safe. Good night.
If you'd like to share more questions, concerns, or experiences, you can submit them through the original registration that you registered to be a participant today, or you can email us directly at trialcourtcares@jud.state.mass.us. And for videos of each of our departmental chief justices, you can reach them at that YouTube page that is linked here. Thank you.